Welcome to the InfoBrokerWorld podcast, where business intelligence meets global strategy, empowering entrepreneurs with the insights they need to stay ahead.
In the dynamic and increasingly digitized landscape of intellectual property, artificial intelligence has emerged as a transformative force across the entire trademark lifecycle, from search and registration to monitoring and enforcement. AI technologies promise a significant leap in efficiency and precision, allowing businesses to process vast amounts of data in real time, uncover potential infringements across jurisdictions, and automate previously manual, resource-intensive processes. However, this technological integration also introduces a complex set of operational, legal, and ethical challenges that require careful navigation by both legal professionals and business leaders. One of the central operational concerns relates to the accuracy and reliability of AI-driven trademark systems. While AI tools significantly enhance the speed of searches and broaden the scope of monitoring, they are not infallible. False positives, where legitimate uses are flagged as infringements, or false negatives, where actual infringements go undetected, can have substantial legal and commercial consequences. AI systems often struggle with contextual interpretation, such as assessing the likelihood of confusion in the eyes of the average consumer or understanding regional linguistic nuances and evolving marketplace trends. A system might identify visual similarities between marks, but fail to appreciate differences in industry sectors or brand reputation. Consequently, any AI-generated output must be subject to rigorous human evaluation to ensure legal accuracy and contextual relevance. The second major challenge lies in the regulatory and legal adaptability of AI systems. Intellectual property laws, particularly those governing trademarks, vary considerably across jurisdictions. For AI to be deployed effectively in a global context, it must adapt to disparate legal systems, some based on the first-to-use principle, others on first-to-file. Moreover, many legal frameworks have not kept pace with the speed of AI development. Existing statutes are primarily designed to address human authorship and decision-making, leaving ambiguities around AI-generated content, autonomous infringement detection, and the question of liability in case of error. Without international harmonization, businesses operating globally may struggle to deploy AI tools uniformly and confidently across markets. Financial considerations also shape the AI adoption landscape. While AI systems can deliver long-term efficiencies by automating routine processes, the upfront investment in software, data infrastructure, and integration is significant. For smaller enterprises and startups, this investment can be prohibitive, potentially reinforcing disparities in brand protection capacity between large corporations and SMEs. The decision to implement AI is therefore a strategic one, requiring careful cost-benefit analysis and alignment with broader IP and digital risk management strategies. At the same time, the sheer scale of content proliferation in the digital space has made traditional trademark monitoring impractical. AI offers the only viable means of managing this complexity, scanning online marketplaces, social media platforms, and web domains in real time across multiple languages and media formats. The capacity to detect visual imitations, subtle naming variations, and indirect brand references is indispensable in an era where infringement is often disguised, decentralized, and executed with increasing sophistication. Beyond the operational and legal hurdles, the deployment of AI in trademark law raises critical ethical concerns. Foremost among these is the issue of algorithmic bias. AI models are trained on historical data, and if these datasets reflect cultural, linguistic, or demographic imbalances, the resulting outputs can mirror or amplify those biases. This can result in skewed risk assessments, discriminatory outcomes, or systematic blind spots, particularly in relation to non-Western cultural expressions, minority-owned businesses, or regionally specific branding practices. Fairness and inclusivity must therefore be actively designed into the system from the outset. Transparency and accountability represent another ethical frontier. Many AI tools, particularly those based on deep learning, operate as so-called black boxes. they produce results without clear, traceable logic or reasoning. In the legal field, where justification, precedent, and interpretability are paramount, such opacity is problematic. If an AI system erroneously flags or ignores an infringement, who bears responsibility? The software developer, the company deploying the system, or the user relying on its output? As AI assumes a more autonomous role in decision-making, clear accountability frameworks must be established to manage liability and risk. AI-powered trademark monitoring also intersects with data privacy and surveillance concerns. These systems often collect and analyze large volumes of user-generated content, e-commerce listings, and metadata. Compliance with data protection laws such as the GDPR in the European Union or the CCPA in California is mandatory. However, legal compliance alone is not sufficient. There are broader ethical implications to consider, particularly regarding the potential chilling effects of algorithmic surveillance on freedom of expression and the risk of overreach in the pursuit of IP enforcement. The potential for over-enforcement is another area of concern. AI systems that are highly sensitive to trademark similarities may issue takedown notices or enforcement alerts for cases that, upon human review, fall within the boundaries of fair use, such as commentary, satire, comparative advertising, or cultural reference. If AI lacks the capacity to distinguish between genuine infringement and legitimate use, it can inadvertently stifle creativity and innovation, especially among independent creators and small businesses. This risk highlights the need for a balanced, human-in-the-loop model in enforcement workflows. Finally, maintaining human oversight is essential. While AI can augment legal processes, it cannot replace legal reasoning, ethical consideration, or strategic judgment. The most effective model is a hybrid approach in which AI handles data-intensive tasks, while legal professionals provide context, interpret results, and manage engagement with third parties, courts, and regulatory bodies. This ensures that legal standards are maintained and that decisions reflect not only technical accuracy, but also commercial sensibility and ethical integrity. In conclusion, artificial intelligence holds vast potential to strengthen brand protection strategies through greater speed, scope, and accuracy. However, realizing this potential requires businesses to adopt a measured, responsible approach to implementation. This includes investing in high-quality data, understanding the limitations of AI models, ensuring human validation of results, and proactively addressing ethical risks related to bias, transparency, privacy, and accountability. Only by embedding these safeguards into the use of AI can businesses protect not only their intellectual property, but also their legitimacy, reputation, and long-term competitiveness in a fast-evolving legal and technological landscape.
Thank you for listening to the InfoBrokerWorld podcast. If you have any questions about today's topic, feel free to reach out via the contact details in the show notes. This podcast was created using AI tools. If you're interested in producing your own AI-driven podcast, from concept to audio, feel free to get in touch. We'd love to hear from you. Until next time, stay informed and stay ahead.